We're now taking you live to court where the controversial LGBTQI bill is being debated in the courts.
We have an affidavit filed on 22nd March.
You are referring to a statement of case filed in support of a substantive suit. Isn't that the case?
Yes, my Lord, we refer to 3 documents. So
what you are reading?
What I'm reading now,
yes,
is the first defendant's amended statement of case, filed on 14th March 2024 at 12:10 p.m.
You refer to an affidavit. I had.
Lord, the affidavit I refer to is the current one, which is opposing our application for injunction.
The difficulty we are having is that the record of the substantive matter is not before us. What is before us is the record of the application. And so we don't have the affidavit you are referring to.
Yeah.
The statement of case you are referring to.
Very well.
You can round up.
Yes.
You're taking up quite a bit of time.
Lady, so it is our prayer that our injunction application respectfully be granted, and we pray accordingly.
So sorry, what I was thinking is that we listen to both sides since they are both attacking you. The application is against you. Yes, so we listen to the Attorney General as well.
Most grateful.
And then you are the principal respondent. So you respond there. Thank you very much.
Ladyship, I'm grateful. Ladyship, the court would note that we have, in a very unconventional manner, not explicitly indicated whether we are opposed to the application or not. That is very much consistent with my philosophy that in matters of this nature, in constitutional actions, the court's duty is to settle questions, to settle important questions of law that arise, and not necessarily decide cases. The distinction has to be made between the court's exercise in settling a question rather than deciding the case. And this is one important matter that, with all respect, I submit that the court ought to settle very fundamental questions that arise in the plaintiff's action. And therefore, the interest of the Attorney General, with all respect, is not necessarily to state a position in favor of one party or not. Because the issues that arise in this matter, for me, go beyond the interests of a specific party and rather impinge on how the provisions of the Constitution, insofar as the exercise of legislative power by Parliament with regards to financial matters, ought to be done. Especially, indeed, the application before you is an application for interlocutory injunction. And I recognize that the plaintiff's main basis are 3. The plaintiff's main basis for the instant action are 3. Firstly, the plaintiff's action seeks to question the power of the Speaker in admitting for consideration by Parliament the bill that has been described as the Human and Sexual Family Values Bill of 2024, a copy of which has been annexed to the plaintiff's application. Secondly, the plaintiff raises issues which allege violations of some provisions of the Fundamental Human Rights chapter of the Constitution, chapter 25. Then also the plaintiff...
Chapter 5.
Chapter 5, I'm sorry. Chapter 5, I'm sorry. Chapter 5. Then also the plaintiff questions... I think that is it. It's only which is carried out. It's a third basis. So those are the two main bases. And my lords, for me, the main basis for the grant of an interlocutory injunction in the constitutional case is whether substantial questions of law have been raised. The court may also proceed to consider the justness or convenience in granting an interlocutory injunction. Indeed, I've examined the court's exercise in this regard since 1996, and I note that in certain constitutional cases, a few of them, it must be stated, a few of them, injunctions are granted. I refer to a qualm against PNM number 1, reported in 1996-97 Supreme Court of Ghana Law Report, at page 117, in which the court granted an injunction in a constitutional action. I will, in the course of the submissions, also examine other decisions of the court in which injunctions or injunction applications were denied. So the court would note that we have set out 3 main issues that have to be considered by the court in adjudicating on the plaintiff's application. The first issue, with all respect, is whether or not the passage of the Human Sexual Rights and Family Values Bill 2024 by Parliament on 28 February 2024, prima facie, constitutes an act under Article 2, Clause 1, Paragraph B of the Constitution, so as to vest in the plaintiff, a citizen of Ghana, a cause of action. The second issue is whether or not prima facie a contravention of Article 108 of the Constitution is disclosed in the processes leading to the passage of the Human and Sexual Rights and Family Values Bill 2024 passed by Parliament. And then, the second one is whether or not prima facie a contravention of Article 108 of the Constitution is disclosed in the processes leading to the passage of the Human Sexual Rights and Family Values Bill 2024 passed by Parliament. The third issue is whether or not the plaintiff's action, prima facie, discloses real allegations of violations of the provisions of the Constitution of Fundamental Human Rights. Especially, I would seek leave of the court to address the second issue, which I indicated as having been raised by us, because I consider that issue very fundamental.
And indeed, the plaintiff applicants dwelt extensively on that.
Yes, precisely. But that issue centers around an allegation of a contravention of Article 108 of the Constitution. Respectfully, 108 of the Constitution, I know has been read by the plaintiff, but if I may, just for the avoidance of doubt and for the sake of emphasis, could say, and leave of the court, I proceed. Parliament shall not, unless the bill is introduced or the motion is introduced by or on behalf of the President. A, proceed upon a bill, including an amendment to a bill that, in the opinion of the person presiding, makes provision for any of the following. Roman numeral I or 1, the imposition of taxation or the alteration of taxation, otherwise than by reduction, or Roman 2, the imposition of a charge on the consolidated fund or other public funds of Ghana, or the alteration of any such charge otherwise than by reduction, or Roman 3, the payment, issue or withdrawal from the consolidated fund or other public funds of Ghana of any money is not charged on the consolidated fund, or any increase in the amount of that payment, issue or withdrawal. My lady, indeed, I would like to rest here because those 3 for me are the most important for the purpose of this exercise. My lady, and the points I note from Article 108 is that, first, the conditional phrase in paragraph A. First, the conditional phrase in the commencement of the provision itself. Parliament shall not, unless the bill is introduced. The conditional phrase indicated there actually restricts the power of Parliament to exercise its legislative authority vested in it by Article 93, Clause 1 of the Constitution. Article 93, Clause 2 of the Constitution. Sorry. And I say that the conditional phrase restricts it because, indeed, the provision itself proceeds to set out the specific matters that Parliament is prohibited from considering, insofar as those matters come within the premises of Article 108. And those are, 1, a bill that, in the opinion of the person presiding, makes provisions for, 1, the imposition of taxation or alteration of taxation, otherwise than by reduction. So insofar as there's any bill which has the effect of imposing taxation or reducing taxation or alteration, imposing taxation or altering taxation other than by reduction, then it shall come under Article 108. Secondly, most importantly for this exercise, the imposition of a charge on the consolidated fund or other public funds of Ghana, or the alteration of any such charge otherwise than by reduction. Indeed, the Constitution does not define charge. But my lady, clearly, the ordinary meaning of a charge on the consolidated fund is a burden being placed on the consolidated fund. So far as there's a burden being placed on the public purse of Ghana, that's the consolidated fund, then clearly such a matter must come within the specific details of Article 108. And then Roman 3 of paragraph A of Article 108 says the payment, issue, or withdrawal from the consolidated fund or other public funds of Ghana of any money is not charged on the consolidated fund, or any increase in the amount of that payment, issue, or withdrawal. Again, insofar as there's a payment, issue, or withdrawal, or a bill which has the consequence of ensuring a payment, issue, or withdrawal from the bill, clearly there must be, from the fund, consolidated fund, clearly there must be recourse to Article 108 of the Constitution. Indeed, yes.
The 108A1 that you read, the one about otherwise than by reduction.
Right.
I'm trying to think of a situation where a bill could reduce taxes without affecting the income or revenue of the state. So I'm looking at how one can be achieved
Roman 1 can be achieved, for example, which does not violate Roman 2?
True. Yes. I think that's a very good observation, especially. And I would say that that's actually the basis for a holistic interpretation of the Constitution. So in construing the Constitution, you do not indeed look at it narrowly. And if indeed the court were to adopt such a constructive approach to interpretation of statutes, which is by looking at the statute as a whole, I would say, with all respect, that indeed, having regard to the, or by virtue of the combined effect of Roman 1 and 2, even such a bill must be caught within the demands of Article 108. That is a bill which is effectively reduces taxation. An argument can be made that indeed, to the extent that such a bill results in the reduction of the public purse, it must come within the premise of Article 108. So indeed, I agree with the court of the observation of my lady. My lady, I make the further point that indeed, Article 108 seeks to place the prerogative of the determination as to whether a matter comes within the premises of Article 108 on the speaker, the person presiding in Parliament. It may not necessarily be the Speaker of Parliament. It may even be another member of Parliament who has been mandated to preside over proceedings. Yes, but that is where...
What does on the person presiding
mean?
What would that mean in law?
In law. But it means a person, it means first and foremost the Speaker of Parliament, or in his absence, a Deputy Speaker, or in the absence of a Deputy Speaker, a person who has been mandated to preside over proceedings of Parliament. Because indeed, if the court were to look at Article...
Yes, and yes. Also, in order not to spend much time on that, what does, in the opinion, also mean in law?
Yes.
What would that require?
Right. So, maybe 2 points. First and foremost, the determination. In the opinion of the person presiding means as per the determination of the person presiding. But secondly, and more importantly, that determination must be subject to the Constitution. Because finally, the exercise of any discretion whatsoever under the Constitution is not unconstrained.
It's not?
Unconstrained. It's not unconstrained. It means it is constrained. And it is constrained by the Constitution. And if there's a dispute, it is subject to the determination of the Supreme Court. The Supreme Court's jurisdiction can be properly invoked to determine whether a person's discretion conferred by the Constitution has been properly exercised in accordance with the dictates or the demands of the provision of the Constitution by which the person is supposed to go by which the person is supposed to go. Now, my lady, indeed, this proposition is not novel. It is one that has been amply established by the court in numerous authorities. I can refer with all respect to J.H. Windsor against the Attorney General, reported in the Supreme Court of Ghana law report.
You mean the proposition regarding discretion?
No, proposition regarding even, specifically even relating to Parliament. Mm-hmm. That even Parliament, the conduct of parliamentary proceedings and powers imposed on Parliament.
Are all subject to the Supreme Court? Subject
to the Constitution itself. So J.H. Windsor and Attorney General established that reported in 1996, 97, Supreme Court of Ghana law report. Mm-hmm. At page 320. It had earlier on been firmly established before an Attorney General, 1980 Supreme Court of Ghana report. Especially, quite recently, even the Abu Ramadan line of cases, the court asserted that even in relation to the Electoral Commission, which has absolute independence in the conduct of elections and the making of regulations. Even the regulations that the Electoral Commission comes up with, subject to the determination by the Supreme Court as to whether it is compliant with the Constitution or not. So I did a firm point to be established that the opinion of the person presiding in Parliament does not confer on that person an unconstrained discretion. And
in order to focus, I would like to remind you of the submission by Counsel for Appellant that, applicant, that in his view, there's been a contravention of Article 108.
right.
And that very occurrence provokes the jurisdiction of this court. And that very occurrence must provoke the invocation, the issue of an injunction.
Right, right.
If you could address that.
Yes, I'll quickly address that. But if I may quickly also refer to a point that we raised in a similar case that we filed in the Richard Sky matter. But in this matter, I didn't file a similar case because the court had not ordered for us to file so. But that point is that indeed, if the court were to look at all the constitutions this country has had since independence, the court would note that a provision in the nature of Article 108 has been present in every constitution, apart from the 19th Constitution, which of course made the president a lifetime president. So from the 1957, even the Independence Constitution, and the provision was replicated, and that was in Article 41 of the 1957 Constitution. And specifically, if I may quickly read, Clause 2 of Article 41 says, except with a recommendation, Clause 2 of Article 41 of the 1957 Constitution, that except with the recommendation or consent of the Governor General signified thereto, the Assembly shall not proceed upon any bill, motion or petition, which the opinion of the Speaker or a member presiding will dispose of or charge the Constituted Fund or other public funds of Ghana, or revoke or alter any disposition thereof, and thereon, or impose, alter, or repeal any rate, tax, or duty. The same thing. Especially in the 1969 Constitution, indeed, provisions of the nature as the 1992 Constitution were first introduced. In 1969, it was in Article 85 of the 1969 Constitution. And it stipulates as follows. Permission if I may read. It said the National Assembly shall not, unless the bill is introduced, or the motion is introduced by a minister, A, proceed upon any bill, including any amendment to a bill, that in the opinion of the person presiding makes provision for any of the following, that is to say, that it lists all the factors there, the imposition of taxation or the alteration of taxation otherwise than by reduction, and then similar provision.
Just to provide some assistance, in the 79 Constitution, the parallel provision is Article?
It is Article 90 of the 1979 Constitution, Article 90.
Yes.
But the point I see to make from all of this is that, indeed, these financial provisions are so important to the nation that the Constitution has deliberately sought to insert them. And the Constitution, in its deliberate framework, once again, seeks to centralize the management of the public purse. And for that matter, the imposition of any charge on the public purse or a withdrawal from the public purse must be done strictly pursuant to the initiative of the executive. But I made this proposition not because I'm a member of the executive, but because by virtue of Article 88 of the Constitution, I'm the principal legal advisor to the government, and as the courts have held from time immemorial, the Attorney General is a protector of the public interest. And therefore, it matters that border on the public interest, the public purse and all, I take a keen interest in. Especially, I say that, indeed, the court, in my respectful view, the bill as presently constituted, and I've taken time to set it out in the other matter, and it's the same bill, for that matter, I'll quickly refer to the particular provisions that I alluded to there. The bill, by virtue of certain provisions, really seeks to impose a burden on the constituted fund. And it is not a position I took after the instant action was filed. Indeed, it is a position I expressed in my opinion to Parliament during its deliberative processes on the bill. I've attached a copy of my opinion to Parliament as Exhibit AG. Respectfully, I allude to clauses.
AG?
Yes.
AG, when...
Yes. I'm sorry, my lady, sorry.
When you were talking about the importance of the discretion and so on, and how the Constitution controls it, I hoped you would go beyond it to show how it should be signified, right, for it to be ascertainable.
Right.
But,
that the discretion is constrained.
You said discretion, so how is it to be signified?
How is it
right
to be exercised?
Yes. Right. But I think first and foremost is signified through the manner in which the particular provision has been formulated. Now, my lady, in respect of this particular case, the court will note that, I mean, as I indicated earlier on, that there is a specific prohibition on Parliament itself from proceeding. And then also, there is also an indication of certain factors that will have to be considered by the person presiding. So the factors to circumscribe the exercise of that discretion are spelled out clearly in the provision itself. That is Article 108.
No, AG, I think that what my lady was asking, if right, I'm not mistaken, is the opinion that has to be expressed by the person presiding. How is it expressed? Is it orally, so that it can be ascertainable?
Right.
So does the person say, I have read everything, and in my opinion, that it goes into the Hansard, or as submitted by counsel for applicant, it should be signified or expressed by the accompaniment of the fiscal analysis. That was his submission. Or, in your opinion, there's another way?
Finally, I would say that those two factors are important, and perhaps I'll add the third one. But the first and foremost, there must be an ascertainable exercise of that discretion. That discretion should be ascertainable that it has been exercised. So there must be a specific determination. That is why I found it a little bit worrying, with all respect, that there seems to be an omission of a determination by the Speaker attached to the Speaker of Parliament's processes. Indeed, the court will know that traditionally I would have raised an objection even to the Speaker of Parliament being a proper party to this action. But I deliberately did not raise an objection because I felt that the matters are so important, such that the view of the Speaker of Parliament perhaps may not be consistent with that of the Attorney General, and for that matter, he ought to be a party. And I felt that if indeed that the Speaker of Parliament is made a party, has been allowed to be a party to this action, and the Speaker of Parliament then contends that he exercised his discretion and actually made a determination that the bill fell outside the premises of Article 108, there must be an exhibition of the exercise of that discretion. So in essence, there must be, if it were a court, there must be the ruling attached. In this case, there must be the proceedings or perhaps an extract from the Hansard of the proceedings by which the Speaker of Parliament made that determination. That is the first step. The second step is that the Speaker of Parliament, it being an exercise of discretion under the Constitution, would have been bound by Article 296 to rationalize why such a determination was made. There must be a reasoned ruling, a reasoned determination to assist not only the court, but the entire nation as to why such a determination was made.
So, AG, you will not accept. Sorry.
And
So you will not accept quote and unquote determination by conduct, that the fact that the person presiding allows it to proceed is an indication that the person's opinion is that it conforms to whatever.
no, but maybe that would be very much unhelpful.
It will not be.
Yes, it
I
will.
just wanted you to say something categorical.
Yes. Maybe it will not be helpful because then it denies an assessment as to the reasonableness or otherwise, or indeed even the propriety of the exercise of that discretion. Then also a third factor is that the Public Financial Management Act, as has been alluded to by the Attorney General, in fact, I stated it even in my opinion to Parliament, has sought to bolster Article 108 by requiring that any bill must be accompanied by financial analysis. Because indeed, again, Malady, I say it bolsters because it reinforces the contention I'm making that there is a centralized process for management of the public funds. And therefore, where there is any charge at all on the public funds, there must be a demonstration of how it affects the public funds or the extent to which it affects the public funds. And if there's also an allegation that the bill is no burden or no constraint on the public funds, there must be that analysis. And that is set out in the financial analysis required by the Public Financial Management Act.
Attorney General, what I am picking up from this morning's submissions and from the processes before us is that not only has the Constitution provided that there must be a determination in the opinion of the person presiding, but the Constitution has gone on through the statute to set out how to assist with how that determination ought to be made.
Precisely. Made. The fact is.
So I have understood you.
Yes, please. The fact is that's true. Indeed, I'll quickly move on to why certain circumstances the courts do not really grant an injunction in the constitutional case. And the reasons are not far-fetched. Right.
You go on, Honorable Attorney General. If I understand what the position you are taking, your position clearly is that this bill imposes a burden on the consolidated fund.
Yes,
that's your clear position.
Yes,
I believe that's the position of the applicant as well. And I also believe that the position of the first defendant is that it does not constitute, if you read his...
yes.
So now we're sitting here, would you...
What you said, it does not constitute...
it does a charge on the consolidated fund.
I don't think that's... Well, he can speak for himself.
Oh, okay. So maybe I'll reserve my question for that. But in my mind, I'll reserve my question after he has, yes, so that I will articulate my points. Okay, thank you. You can proceed.
So, indeed, to assist the court, I refer the court to clause 2 of the bill, which places a collective responsibility on all organs of state, including even the judiciary and state institutions, to promote the values enshrined in the bill. Maybe nebulous as promotion of the values of the bill is the concept, and we pointed it out in our original opinion, was still not corrected. That how is a state institution required to promote the values of the bill? Is it through education? If it is through education, it is still a constraint on the public purse. So promotion of the values of the bill required of all organs of state and state institutions will involve a charge on the constitutional fund. B, the criminalization of various acts. Clearly, an enforcement of which will require the work of investigative bodies and security agencies of state in various provisions of the bill. But it's not cheap at all to prosecute. It is not cheap at all to criminalize actions and to prosecute. It may seem to be free, but it's not free at all. It's actually a heavy burden placed on the constitutional fund. Then the provision of prison facilities, which will be a consequence of clauses 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, and 14 of the bill. No doubt will require a charge on the constitutional fund. Again, there is also a duty placed, I would say a power which has been conferred on the minister responsible for culture in consultation with the ministers responsible for health and gender and children and social protection to make regulations under the bill to regulate various matters provided by the law. It may seem to be an act that is exercised in respect of other laws, making of regulations by ministers. But mainly the point is that hitherto, until recently, there was no such thing as private members' bill. So indeed, there was no such requirement.
This is the question I wanted to ask all of you, but I thought I would hold on till I had heard from Parliament whether in our constitutional histories, from First Republic to Fourth Republic, we have had a private members' bill such as this.
Especially, indeed, the situation is novel, and it occurred only in the life of the 7th Parliament, which was from 2017 to 2021. It was in that time that the Speaker, the former...
In the very last
Parliament.
The very last Parliament.
Yes, that's the Speaker of Parliament, then Professor Michael Quay, quite innovatively encouraged the initiation of private members' bill, and it was the first private members' bill. It did not involve any charge of reserve fund at all.
Which was?
I forgot the assignment. I think was not a very controversial assignment matter, and for that matter, it didn't really. But there was one such bill. I believe the Council for the Affairs for that may assist the court in that regard. But the first bill was introduced in Professor Michael Quay's tenure as Speaker of Parliament. I think 2019 or so. And especially so, hitherto there was no such concern as to the implications of a bill for Article 108, because all bills emanated from the executive. So there was implied in the introduction of such a bill a consideration of the financial implications. And indeed, there was no concern because the basis for the Speaker to exercise or the person presiding to make a determination did not arise because it was from the executive. But that is why I consider this point so important that I think the court ought to be given an opportunity of determining the issue, whether indeed there has been an infraction of Article 108 or not. Because from 1957, the provision has been present in every constitution the country has had, apart from the 1961. And the 1960 was quite peculiar, as you said. It gave somebody a life president status. So that's quite different. And if such a question has not been determined by the court, I think with all respect, the court has to be given an opportunity. And my preference, I would say, would be for the court to preserve the status quo, determine the question, and then if the determination is made whichever way, then the nation can move on.
Determine which question? Determine the question in the substantive suit? No. Or determine the question in this application?
No, determine the questions in the substantive suit.
The substantive suit.
So pending that, then there ought to be a preservation of the status quo for the court to be given an opportunity of determining. So this then also ties in with my examination of certain cases in which the Supreme Court has refused an injunction. And I'll first start with Wilford Kwaku, against the Attorney General, reported in 2012, Volume 1, Supreme Court of Ghana Law Report, at page 259. It is the Supreme Court, constituted by a single justice of the court, Justice Datiba, declined to grant an injunction. Because, respectfully, it was an action that related to a move to halt the creation of electoral districts under the Local Government Act. So, that was a peculiar case. There was the creation of electoral districts by the Electoral Commission, and indeed, the application was filed only or determined only in June 2012, 6 months before the election. It have had an effect on the election, conduct of the election. The court in its wisdom actually stated, held at page 260, that in the interest of the public, the collective interest of the public, said that where the relief sought relates as here to a public law matter, particular care must be taken not to halt the action presumptively for the public good. The action was for the public good, and therefore the court declined it. Maybe the second case occurred in the same 2012, and that is Ransom France. As for France, number 1, against the Electoral Commission and Attorney General, was filed in July, I think it was filed in August 2012 by my good self. And the court determined it in September 2012. Mind the court will note, clearly, it involved the Electoral Commission. It sought to restrain the Electoral Commission from laying before Parliament regulations that had enacted for the conduct of the 2012 elections, 3 months before the elections. And for that matter, the court dismissed my application for interlocutory injunction. I was not peeved at all. I moved on with my life. So clearly, it is only where the court considers the collective good of the nation. And I would say that in matters that border on withdrawals from the constituted fund or the use of the public purse, as I have, with all respect, demonstrated before you, the collective good actually will be in respect of holding a status quo for the court to indeed determine whether the bill that is being sought to be, for want of better expression, rushed, is in the public good or indeed affects the public purse. If the bill affects the public purse, then with all respect, the court owes a duty to halt the progress of that bill. I would also quickly address the point that this is actually not a case where the law in question is at its formative stages or going through the processes in Parliament. Indeed, all the processes in Parliament have been completed. Parliament effectively has concluded the processes. And indeed, now, if what is supposed to be transmitted to the President will actually be titled an act, it is just left to the signature of the President and then to become law. And I would say that, having regard to the completion of the processes in Parliament, what Parliament has done will constitute an act under Article 2, Clause 1, Paragraph B of the Constitution. That is an act, a small act, not the act with a capital A, Act of Parliament. It is an act with a small a, which is an action or a decision.
And so your presentation or your submission is that the jurisdiction of this court has been properly invoked?
Yes,
for this application or for the substantive action?
Pardon me?
For this application or for the substantive action?
Oh, I'm only saying so because of the requirement in injunctions to show the
Prima facie
case as well as a substantial important question of law.
I think, can you clarify that point? I think I missed it. You are saying that Parliament has completed its processes, its procedures, and that what they are seeking to do is an act that's beyond its proceedings.
No,
is that what? Yeah,
but I'm saying that now we can actually find an act having been committed, and the act has been committed. In fact, 2 acts. First is the opinion of the person presiding, which in itself will constitute an act. The determination by the person presiding will constitute an act by the person, not an act of Parliament. So once there is that act committed, it can be basis for the invocation of the court's original decision. Secondly, the completion of the processes in Parliament pursuant to the exercise of that discretion by the person presiding by Parliament will also constitute an act that can be brought within the premises of Article 2, Clause 1, Paragraph B. And indeed, I just want to have to emphasize that it's not an act of Parliament I'm referring to. It's an act as in a decision or a step by a person.
To help all of us, I think that I want to read 2(1)(a). A person who alleges that any act or omission of any person is inconsistent with. This is what you mean. Attorney General?
Yes, Mr.
Any act or omission.
Yes, Mr.
And your submission is that there is an act.
As in an action by a person, yes.
And there are 2 acts actually.
Yes.
This is your submission.
Mr.
The first act is the determination by the person presiding. And the second act is the completion of the proceedings.
Processes in Parliament, Mr. Fidaso. So I pray to rest my submissions, except as the court may have some questions. The court has no questions. May I rest?
Standing clearly, your position is that we hold matters in abeyance to abide the outcome of the hearing of the substantive suit because of the gravity of the issues that have been raised in this application.
Yes, Mr.
That is what you are saying.
Mr. That is so. Okay. So, because it's quite new, and the court ought to be given an opportunity of efficiently determining it. Yeah, there we go.
Because this is the first time like this sort of action has occurred.
Yes, Mr. Fidaso, since 1957. Indeed, even in for Kwaku and all, the questions really were not so novel. I remember even filing an action in 2011, Akoto against the Attorney General, Bafos Akoto against the Attorney General, in which I raised the propriety of the case of distress by the Minister of Local Government there. So those cases were really didn't really raise any new questions as this one.
But whether or not under Article 108 and the parallel provisions previously, there is a deliberate intention by the framers of the Constitution to centralize the management of public funds. That would be the framing of the question that you invite the Supreme Court to do.
Yes, Mr. Fidaso. I will not even go into the human rights arguments. Properly speaking, we can even contest at the High Court the human rights. It's not really for this court.
Thank you. Oh.
But AG, before you sit down, it is your case that there was no determination by the person presiding that it was going to be a charge on the consolidated fund. Don't you think that is an omission itself?
Well, it's really, yes, I really recognize that if there was no such determination, then it would be an omission.
And Article 2(1)(b).
But I would be hesitant in saying so because I would say that there's no evidence of such exercise.
Thank you.
As a lawyer, I would say that there's no evidence of such an exercise. My lawyer friend asserts that there was such determination. I would say there's no evidence of such determination.
So sorry. You've heard the broad scope of all the submissions. Yes.
We are vehemently opposed to the application, including the supplemental arguments made in support of it. My Lords, the first ground upon which we are opposed to it is that this application is the same application that was previously brought before this court.
I think the submission made by counsel for applicants was that changed circumstances.
I will deal with it.
All right.
I'll deal with it. And my Lords, we have deposed to it elaborately in 2 main paragraphs, actually more than that. Paragraphs 11 to 16 of our affidavit in opposition. Paragraphs 11 to 15 of our affidavit in opposition. 20 page 1 to leave of record, yes. That's it.
It's 11 to
15. My Lord's attention is drawn specifically to paragraphs 11 and 12 of that same affidavit. In those 2 paragraphs, we take time to break down the arguments made in the earlier application and compare them to the present application. And we reach the conclusion that it is the same. Now, I'll deal with the additional aspect. It says that the only difference between this application and the previous one is that there has been a continuation of the legislative process, which is that it has reached a different stage. But in the previous application, our answer is simple. In the previous application also, it sought to injunct a particular stage of the legislative process. And our affidavit in opposition attaches the previous application, which merely sought to restrain Parliament from proceeding with the bill. And we say that it doesn't matter that this time you are saying that Parliament should be stopped from transmitting the bill because Parliament is still proceeding with the bill. That is the simple answer to that, this supposed new fact.
So the first time it sought to injunct Parliament from proceeding with deliberating. And this one is seeking to injunct Parliament from transmitting.
Actually,
that's the difference?
Yes, my lady, it doesn't add deliberating. It just says proceeding.
I'm evaluating.
Very well.
So I'm asking you.
Yeah, it only says proceeding. And proceedings would include deliberations as well as continuing with this duty to transmit it to the President. And so it is not a different application. In respect of that application, so in substance and everything is the same. In respect of that application, this court on the 19th of July 2003 made specific findings and held as follows. In fact, an enhanced panel of this court said, we have considered the merits of the application before us. It is our considered opinion that a prima facie case has not been made. So first of all, on the same arguments, in substance, the court made the finding that no prima facie case has been made out. The court made a further finding that no irreparable damage has been established by the plaintiff to warrant the grant of the injunction. And I'll go back to some of these facts.
Mr. Sir, before you proceed, I just want a little clarification. Yeah. Are you saying that we are bound by this interlocutory decision?
You should generally be bound by it, especially that it was an enhanced panel of the court.
Is that the position of the law, that in interlocutory matters we are bound by a decision?
Well, my understanding of the position of the law is that the court is bound by its decisions on principles of law. And if the court decides that in interlocutory matters it's not bound, I will at least persuade you with it, because I don't see that distinction clearly in my reading of the Constitution.
From what you are saying, you appear to be urging us to consider ourselves bound by this decision. That is why I have a little problem.
Yeah, maybe let me
because if there's a principle of law that you want us to be bound by, then please articulate that particular principle of law from this decision.
Very well.
That you think we should be bound by that principle.
I'm most grateful, my Lord. The principle of law is that the three-way tests established by this court in the so many lopsided decisions of the court in matters like this say, first of all, that you should establish serious issues of law to be tried by the court. Secondly, you should show that irreparable
the
damage.
just factor.
And the just and convenient. Very well. And this court reiterated in the same case on the same facts, the same principles, applying it to the facts which are the same as now. And so if the court even decides that it's not bound by its previous decisions delivered by an enhanced panel in interlocutory matters, I will urge it on the court that there is nothing new in this case that will justify that departure. I'm most grateful for giving me the opportunity to clarify this matter.
But Mr. Sori, at that time, Parliament had not completed its work.
At this time, Parliament has not completed its work. Parliament's work includes, after the last full debate under Article 106, to transmit it, that's part of its work, statutorily and constitutionally.
So is Parliament able to return this bill for debate, further
Absolutely,
debate?
I was going to make that point. And some of the questions that came from the court earlier hinted at that when Parliament sends it to the President has options. He has a discretion whether to assent to it or not. The President can return it to Parliament to take into account some of these arguments that they are making in support of their case, to reconsider the bill. The President has that power under Article 106, Clause 7 and 8. Then the President can even refer it to the Council of States for advice on it and tell Parliament that I have referred it to the Council of State. And so this application in the court says no. We shouldn't even allow the President to decide whether he can engage Parliament on the very issues that his principal legal advisor could tell him that right now, tell Parliament to do this. They say he shouldn't even get there, so that he will take his advantage of his constitutional obligation.
Oh, Mr. Sori,
yes.
Let's be on the same page. If I understand, and I think I do, the applicant and the Attorney General.
Yes.
In fact, the Attorney General presented an enhanced position.
Yes.
The Attorney General identified, or the applicant said, that there has been a violation of the Constitution. It started when the deliberations started without the fiscal impact analysis. And that violation more or less was completed when Parliament got to the end of its work without still having the benefits of the fiscal impact analysis. And then he also pointed out that even in the submission that there had been the consideration required by Section 100 of Act 921, what you attached is an extract of the LI, but not a fiscal impact analysis.
Yes, ma'am. Already.
If I may complete.
Sorry.
Then the Attorney General went on to say that there were two acts within the genre of Article 21B Acts. And these two acts is that one, the person presiding did not make a determination. And that determination should be made from objective indices. And the second act is that Parliament completed its deliberations, ended with a bill that's ready to transmit without the fiscal impact analysis. So the person presiding did an act or an omission or both, and Parliament itself as an institution did so. I think that that's the submissions that have been laid on the ground.
Yes, my lady. And I say it has always been the same submission. The reason why they came to this court, first of all, was that that determination was not made. That was the point that has always been made, first of all. Secondly, the argument that no determination was made was previously even made by the plaintiff in the plaintiff had in the earlier application said that by failing to expressly state and record the reasons for proceeding with the bill or otherwise, a decision had been made by that. And that, I'm sure that's a question that my lady to your left was asking, that in other ways, we will not accept an omission or a conduct that suggests that that decision was taken, except if we see it in writing. And I'm saying that throughout the history of parliamentary proceedings, in respect of the constitutional provisions that reflect this constitutional provision which has caused this suit, the question is whether it is always the practice for the person presiding to make that determination in writing in respect of every bill that comes to Parliament. The practice is that that doesn't exist. In any event, I want to look at the rules.
Council, have you even stated that in your affidavit, that practice that does exist, for them even to have an opportunity to rebut it?
We have.
You are just spinning it out right now and from the bar, and I think that's.
I will answer that. My lord, in the plaintiff's arguments, the plaintiff strayed into the statements of case that were earlier filed, including affidavits that this court had impliedly struck out, and then even ordered me to file the present one on which we are dealing. And I'm speaking from the same statement of case. That very well. My lord said they didn't have it, but that's, I'm responding to that point. And my lord, let me just go ahead and make this point in respect of the provision itself. It's where he made it actually. My lord said you didn't have it, but I was responding to that. The provision says this: Parliament shall not, unless the bill is introduced or the motion is introduced by or on behalf of the President, proceed upon a bill, including amendment to a bill, that, in the opinion of the person presiding, makes provision for. Throughout the submissions, I've not heard the point made about the meaning of makes provision for. The question is that the submission I'm making to the court is this: all that the person presiding is required to do is to find out whether the bill on the face of it makes provision for. That is the meaning of the rule of the constitutional provision.
So, I'm sorry. This is how we should construe Article 108(1).
No, the submissions that we're making all said that it imposes on. It imposes. It imposes. So it's their reading, and if you listen to the submissions of even the Attorney General, it is to the effect that it's likely to impose because of the following consequences. But the question is that the constitutional provision? Is that the wording of it? That is not its wording. So it is okay if they say it is likely to, or it has the effect of. That I can relate to that argument. But are we still construing the provision or saying that when the court comes to deal with the substantive matter, the court should consider reading it in a particular way to give it that effect? That is a totally different submission. And I am also submitting to the court that let a clear distinction be drawn between an act of Parliament that it is alleged has not been complied with, as distinguished from a constitutional provision that has been violated. So it is not right in invoking the court's original jurisdiction, which is to determine whether a constitutional provision has been acted in contravention of, or there has been some conduct that is inconsistent with it, to say that, oh, let's go and understand that constitutional provision by bringing provisions of a statute, which, as we speak, is being litigated by the same parties in the High Court in respect of the fiscal impact analysis under Section 100 of the Act. That matter is before the High Court as we speak.
I'm sorry, you've lost me on the point you are supposed to have made just now.
Yeah, very well, very well, very well, very well.
You would have to reiterate it.
Yes, very well. So the first thing I said in relation to Article 108 is the fact that all the submissions I've heard so far don't address that key phrase, makes provision for. So does the Act make provision for? Indeed, in response to a question to the Attorney General about private members' bills being introduced, the Attorney General said he recalled one in the past. And I believe the one he recalls is the one that had to do with the Road Traffic Amendment Act. That also included provisions with the likelihood of people going to jail. It was a private members act. It was assented to, and we didn't have these issues. And so, my lords, I'm urging the court to follow its previous decision where it laid it down that presumptively, the court will not injunct this process, which has not reached a point there's nothing dire in it, because the president may exercise his various options to get what their very issues that they are articulating before the court addressed. At the very best, they should submit it to the presidency. They should not let this court arrest by way of an injunction. That process.
But Mr. Sorry, I recall presiding over that matter. So yes, I can actually tell you what went into that decision, which is that the matter was still in Parliament.
Yes.
And whatever it is we were being asked to consider in relation to Article 108, it could be cured. It could be cured. Right now, you have completed your processes and you have a bill. Is it your submission that it can still be recalled for the purpose of curing this alleged omission?
Certainly, and that's exactly what I've been saying. So first of all, it is still in Parliament because by virtue of the pending process, the president has not accepted.
That's why they're saying that. That's why they're saying that we should use our power to keep it with you until you correct what you have done.
And secondly, I'm saying that the concerns they are raising.
Do you understand?
The concerns they are raising are matters they should send to the presidency. If it gets to the presidency, the constitutional provision that requires Parliament to mandatorily at this stage not be keeping it with Parliament, but to send it to him, allows him to take into consideration their proposals and send it back to Parliament for reconsideration, and Parliament can incorporate it.
I think
that is the constitutional.
But I think the point my Lady Chief Justice is making is that they are alleging a grave violation of the Constitution, in the sense that something that ought to have been done before this bill was, as it were, completed, was not done. You understand? And they are asking this court, because of that, to take a decision and restrain Parliament from proceeding to perpetuate an act which constitutes a violation of the Constitution. You are saying that they should rather take it to the presidency for whatever remedies that they can obtain there. And my lady is asking you, what if it's a matter that constitutes a grave violation of the Constitution? What prevents us, as the apex court of the land, from taking the decision on it? That is the question we want you to address.
There were three answers. First of all, there has never been anything like, our constitutional history doesn't admit of anything of like an infinitesimal violation of the Constitution. Every violation of the Constitution is grave. Two, this is an alleged grave violation. They put the tag grave violation. I'm saying that
they put the tag novel.
Well, it refined to novel, and in many instances, if not in all instances, the matters that come here are novel, because if they were interpreted, we will not become accept Article 185 or so. Was it 181 clause 5? It has come here a number of times, but the court has said that if this court has determined a matter before, don't come back here. It will be enforced by the lower court. So as for novel, grave, all of that, it is not a ground at all. It shouldn't even be canvassed in this court. As if to suggest that oh, some of them, we could just treat them with levity. I will get to the cases that he cited about, oh, some involving the creation of new districts. What is happening at SAL? So there will always be these matters, and there will not be little. In any event, we say that nothing irreparable will happen if this court does not. What this court rather is invited to do is to do something that I don't think is constitutional, because it is a process that must be followed. And all of the things that they are urging on this court are capable of being decided and determined and catered for in that process as we speak. Why are they thinking, in fact, the key question that came from the bench, which still hasn't been answered, is why don't we trust, and the Constitution has given the power to do it, why don't we trust that the president will do it? Unless there's no such allegation too. So, in every way, there's nothing new in this particular matter.
But the issue, Mr. Story, the issue is, do you, your client, Parliament as an institution, if Parliament as an institution agrees with them that there is a missing vital link in the considerations it should have done, why should it allow this court and allow the executive and allow the country to be expending energy on this question? If you agree with them, correct your omission. If you don't agree with them and you insist that you have done all that needs to be done, then say so. Oh, but you can't present a vacillating position even if there is a gap, it can be fixed between the two institutions. Has there been a violation or hasn't there been a violation? If you agree there's a violation, can you go and fix your violation? If there hasn't been a violation, can you say so? So that there's a determination of that.
Very well, Malid, I think that is the point where I lost you. The submission I made to this court is that there is no violation. And I read the rule saying that, does the bill make provision for? All I hear is that it is likely to have the following impact. Does it make provision for taxation? Or does it have a provision which says, in respect of this particular matter, it should be charged on the consolidated fund? It doesn't have any such provision. All they submit to this court is that there is a likelihood that that will happen. And I'm saying there is no such violation. Indeed, I have attached to my affidavit in opposition Parliament's reaction to the Attorney General's position. The current one, the prevailing one, filed on May 20th, 2024, Exhibit 3. And I've referred in my affidavit particularly to paragraph 7.13 at page 8. So all of his impact analysis issues he's talking about. Yes.
You are speaking about your affidavit in opposition of 20th May?
Yes, ma'am.
It's made up of 7 pages.
No, my lady, there are exhibits.
Which exhibit?
This exhibit 3.
Exhibit 3.
Yes, my lord has found it.
Yes, okay. Please go on.
Yes, so my lord realized that in paragraph 7.13, Parliament's committee notes that the committee wishes to indicate that the concerns of the Attorney General have been taken care of in the committee's proposed amendments. That is very clear. That all of the issues that the Attorney General said, oh, he advised them on, Parliament did. The court is referred also and the court is referred also to paragraph 8.2.
Short paragraph.
No,
the 3-line paragraph.
Well,
is what took care of the Attorney General's concerns.
And in that paragraph, it's a well-loaded paragraph. It says it is being. Oh wait, my lord. It says it attaches. My lord will look at Appendix A of it. They have listed all the various amendments. And actually in paragraph 8.2 also, it says, in the light of the above constitutional imperatives, the committee decided to seek the opinion of the Attorney General and Minister of Justice on the bill. The Attorney General's concerns were duly considered. I think we should trust Parliament too. That this is a report coming from Parliament, that these concerns that are now relied on by the Attorney General.
I think I'm understanding you in this light. You are submitting that there has been a determination by the person presiding in these clauses.
First of all, yes. Secondly, their contention based on the clear tenor of the rule cannot be correct. Thirdly, all of these matters can still be taken care of in the legislative process.
This is where I come back to my position.
No.
I have one position.
No.
Have you contravened? If you have contravened, do you want to go and repair? And if you haven't contravened, say so that don't push us into writing. We start here. It's 12:30. If you haven't contravened, have a firm position on that.
Yes,
then we know what to do.
That is so. And there's a report from Parliament which confirms that. And they've not spoken about it.
Mr. Sorry, I'm sorry. Let me just ask. The Honorable Attorney General was talking about a process which is ascertainable.
Yes.
You understand? Yes. Now, what can you put before this court to satisfy us, to enable us ascertain whether the constitutional duty that was imposed on the person presiding had been duly complied with? What evidence do you have in your processes?
Exhibit 3 is clear.
Which one? Which one?
3, the one that I've just read to you, said that it is in reference directly to what the Attorney General put before Parliament. It says that.
But Mr. Sorry.
Yes.
If you look at 7.1.3.
Yes, my lady.
The committee wishes to indicate that the concerns of the Attorney General have been taken care of in the committee's proposed amendment.
Yes, my lady.
If I have concerns and I convey them to you, should you say that you have taken care of them so I should be satisfied?
Very well,
or I should be satisfied by what you have done, that my concerns have been addressed, in which case I will stop complaining.
Or you should show me what you have done, rather than tell me that you have done it.
My lady, between Parliament, which has the power to decide or to proceed in the manner in which it is proceeding, and which had no obligation to, even in terms of the legislative process, to seek the Attorney General's opinion. It sought the Attorney General's opinion and assured the Attorney General that, yes, I have satisfied your position. And that is the last point between the Attorney General and Parliament.
But respect.
But if you say you have satisfied the concerns of Attorney General, how?
And respectfully,
in terms of their proposed amendments.
Mr. Sorry,
Yes.
respectfully, this is the bone of contention here.
As I should.
Here, the applicant said you should have attached a fiscal impact analysis to the bill. Then the Attorney General said there should have been a determination even on record. And third, within the bill, there are clear provisions that require a charge on the consolidated fund. And there has been nothing attached to show how the mathematics, the money, the cedis and the dollars are going to be determined, and that this is the requirement. Is it your suggestion that the arithmetic is not a requirement?
It is, first of all, not a requirement. It will only be a requirement if, first of all, the bill, the Attorney General had got up and read part of the bill, which showed a charge on the consolidated fund. And I've made this argument so many times, that the reading of the rule does not require what the Attorney General and the plaintiff are saying. It says if the bill makes provision for. So it would have even been a point to consider if the Attorney General had read one part of the rule to say which of them imposes a charge on the consolidated fund, in order for us to even to go into a further interrogation of this matter.
We will wait for your submissions on that in the substantive action.
Very well. And my Lord, this court made that determination in the same application that came before this court, that it will rather abide the substantive hearing of the matter in order for us to go into to these issues. So that is the first point. And I'm saying, in any event, the legislative process doesn't end with the full and final debate. It still continues. Yes, because the bill could still come back to Parliament based on all of these arguments, brilliant arguments that have been made in this court. It could still come back to Parliament. And so it will be a presumptive injunction at the moment, because the process hasn't been exhausted to where all of this cannot be done, even if they were not done. That is the point that I was making. I've always been making. That first, the provision doesn't say so. Two, assuming without conceding, Parliament still retains residuary jurisdiction to deal with that. If he thinks that his opinion with Parliament says it has dealt with, has not been dealt with, he should advise the final person to refer it based on this, because they didn't take into consideration that. But at the moment, we'll be presumptively injuncting something that has no likelihood even of perhaps of becoming law whatsoever. And the questions that earlier came from the bench were quite clear.
So, Mr. Sorry, if I get you right, the legislative process comes to an end only when the president signs the bill into a law.
Yes, my Lord.
If he doesn't sign the bill into law, it's still in the process.
Absolutely. It's in the Constitution, Article 106, Clause 8. It is clearly stated that the president can decide whether to assent. He has three options. Either to assent, or take it back to Parliament and say, Parliament, look at the following provisions. They impact the consolidated fund. So can you amend them? The Parliament has an obligation to look at it. Or it could even decide that before taking it back to Parliament, or sending it back to Parliament, consult the Council of States. So all of these options, the plaintiff and the first defendant, they are not satisfied. They say, oh, let's assume that that process will still not be done. Let's assume that even when I advise, as a principal legal advisor of government, when I send my arguments to him that even though I had advised Parliament, Parliament said they had done what I said they should do, but didn't do it. So tell them to go back and look at it. The position now is that let's presumptively injunct the situation. And the string of authorities that have been before this court, starting from the Wilfred Kwaku to Ransford France to Haruna Idrisu and
no, Mr. Sorry.
Yes,
Mr. Sorry. If you want to cite a case, kindly do so that we can consider it.
Oh, very well.
You know, for instance, Wilfred Kwaku was cited.
Yes. Ransford France was cited.
France. So if you want to add to the cases, do so.
There is Haruna Idrisu and two others, which even makes... Yes. It is writ number J1/9.
Is this the e-levy matter?
E-levy matter. I can cite it as such, unless you give me leave.
That matter has not been settled. It's only...
No, that was an injunction application that came before the court.
Wait. All right. So you are referring to the ruling on the injunction application?
Injunction, yes. In which the court even applied the presumption of regularity. There is in the Bugri number 1 versus Attorney General also. It's 2013 to 2014, 2 in the Bugri number 1. (2013 to 2014) 2 Supreme Court of Ghana law reports at page 1134.
Repeat the citation. I was consulting with my brothers. Mr. Sorry.
It's 2013 to 2014, 2 Supreme Court of Ghana law reports at page 1134. There's even Attorney General versus Commission on Human Rights and Administrative Justice number 2. 1998 to 99, Supreme Court of Ghana Law Reports at page 894. My Lord, and I want to refer to some submission also that was because I'm on the line of authorities. Let me deal with the arguments on the line of authorities. They compared the situation to the Ghana Independent Broadcasting case cited by the plaintiff and the first defendant, in which an LI was placed before Parliament and an injunction was granted to restrain its ripening into law. The biggest difference, and I'm glad...
An injunction was granted or injunction was applied for?
It was applied for and granted. The biggest difference in this particular case is the point that I've been making earlier on. That in that particular case, it was subsidiary legislation. After the gestation period of 21 days, it ripens into law. It doesn't come back. So that was an imminent danger. It was an imminent danger. It was likely to happen. In this particular case, it's a very remote danger. The remoteness is that the first defendant against whom I'm arguing...
Is there danger? Is there danger? I keep bringing you back to it. If there's danger, acknowledge that there's danger.
There is no danger.
Go and remove the danger.
At the moment...
Because this is in your remit. Go and remove. Go and fix it. And if there isn't danger, tell us that there's no danger.
There is no danger at all. In fact, the danger is far, if there was any, it was removed even by the Attorney General, who in this court reminded us that he's the principal advisor of government. The thing is coming before him to decide whether you are sent or not. Take it back, say, under the law, I require you to look at it. So there's no danger at all. He has full control over that process. And he should take control of it rather than leave than call for the court to assist him. So, Ghana Independent Broadcasting Corporation, in which the injunction was granted, doesn't apply. Then there is Michael Akuma Nimfa versus Judge Kwesi, which was also cited. If my laws take a critical look at that decision, my laws won't apply it, and I'll give a reason. That case relied on too many cases involving private matters, injunction, Pujabi and Nami, and all of that. There was no focus on the clear grounds on which this court grants.
Which case is that?
Michael Jachukwesi. It was
No, I recall. I was very much in that matter. That case was premised on the point that
their Titus Sorry, lawyer to the Speaker of Parliament. Now, they were debating some key issues. The CJ, they're grilling him for answers. Lawyer for Amanda Odoi, Ernest Yao Ako, filed an interlocutory injunction restraining Parliament from transmitting the bill to the President for assent or otherwise. Now, his basis is that this bill is a private member's bill, and it will impose some sort of charge on the public purse. Now, they argue that per the dictates of Article 108 of the 1992 Constitution, Parliament is constrained. His view is that such a bill should emanate from the presidency, and that's the challenge as we speak, where the AG took the floor, gave his submission, and then Titus Sorry took the floor explaining his own side of the deal. He speaks for the Speaker of Parliament. And so the contention here is that, has there been a breach of the Article 108 of the 1992 Constitution? That's where the debate is at right now. And we're going to be in court all day. We're taking a quick breather. We'll be back with more. Just stay tuned in.